Please be seated. The court is now back in session. I hand over the floor to the defense team for Mr. Nguyen Chia to resume his closing statement. You may proceed, counsel. Counsel Sunarun. Thank you, Mr. President. I shall now resume my closing statement. Additionally, without more, the mere fact that certain evacuees were originally city dwellers or members of the former colonial regime is not sufficient to establish the elements of political persecution. The fact remains that the co-prosecutors are unable to point to any witnesses with direct evidence of the quote-unquote new people being singled out or treated in a discriminatory manner by the Khmer Rouge cadre. The same can be said of their allegation that former colonial soldiers and associates were targeted. There is literally no evidence to prove their allegations. Now let me pause for a minute on the way that the co-prosecutors have failed in their attempt to show a discriminatory intent towards former colonial soldiers. Citing two lone witnesses in support of this allegation, the co-prosecutors claim that, quote, the Khmer Rouge soldiers killed transferees, particularly those associated with the colonial regime, unquote. Yet once again, a review of this evidence reveals the marked unreliability of their claims. Ms. On Ma, in a statement untested by cross-examination, recounts witnessing her husband taken by Khmer Rouge cadre following an accusation that he was a former Republic captain. On Ma does not state that she was a witness to her husband's killing. Instead, On Ma speculates on his death because she recognizes a Khmer Rouge cadre wearing his shirt and scarf in an unspecified time after his appearance. This one statement does not come close to establishing that Khmer Rouge cadre targeted and killed former Khmer Republic members, or that they had a policy of doing so. The evidence provided by Pich Sripal is even more attenuated. It is based solely on hearsay and speculation. In her statement, Pich Sripal alleges only that a group of the former Khmer Republic regime was sent to Phnom Penh for work, and that later she learned that certain members of the group had died. Neither witness provides direct first-hand knowledge of killings based on evacuee status as former Khmer Republic members. Neither witness comes close to providing evidence necessary to establish that a pattern to target this group existed. On the contrary, witnesses indicated that they were not mistreated during the second movement. Many reported that they were provided with basic necessities by the Communist Party of Cambodia. Others indicated that they were happy to join the second movement. As Lai Bunni testified before the co-investigating judges that, I quote, "We were happy to go because we knew that there was a lot of rice and fruit in Battambang," unquote. Of the witnesses who did report poor conditions and treatment, nothing suggests that such conduct was based on their affiliations as 17 April people or their affiliation to the Khmer Republic. Similarly, neither the co-prosecutors nor the co-investigating judges before them have advanced a shred of evidence that anyone in the party center, including Nuon Chea, acted with the specific intent to cause injury to evacuees because of their former association with the Khmer Republic or as new people. Neither is there any evidence that Nuon Chea participated in an agreement, designed any plan, issued any order, or instigated any person to inflict condition amounting to political persecution as presented by the co-prosecutors. A reasonable trier of fact must therefore conclude that the co-prosecutors have not proven beyond a reasonable doubt that Nuon Chea is guilty of political persecution. I will now move on to the charge of religious persecution. The claim has been made that Nuon Chea is guilty of religious persecution committed against Cham Muslims in the course of the alleged Phase 2 population movement. I need not spend too much time addressing this charge, as the evidence wholly and completely fails to support that allegation. The co-prosecutors apparently agree. Their previous requests highlighted in our brief that the chamber specifically exclude from consideration the allegation related to the Cham that are included in some of the paragraph discussing the second forced movement, because no witness were heard in this trial relating to the forced movement of the Cham population, clearly indicates their belief that no evidence exists to support this charge. The submission in their closing brief echo this belief. For obvious reasons, the defense agrees. As our brief makes clear, the evidence before the chamber reveals no direct first-hand evidence of religious persecution in the course of the alleged second population movement. Even though evidence cited in the closing order establishes that Cham Muslims were amongst the persons moved during the second population movement, that allegation is prima facie insufficient to sustain a charge of persecution. The only conclusion supported by the evidence is that the experience of the Cham during the second population movement was not unique. All transferees during the alleged second population movement experienced similar treatment regardless of religious affiliation. Literally, no evidence exists to establish that Cham were singled out during the second evacuation. Treated in a discriminatory fashion or forced to ensure worse conditions than other evacuees. Likewise, no evidence of any specific intent or policy on behalf of the CPK to discriminate against the Cham during the second movement has been produced. As such, the only available option for the chamber is a finding of not guilty. Now, I will turn to the charge of other inhumane acts through enforced disappearances. As we have articulated in our brief, we maintain that this charge cannot be sustained because it violates the principle of legality. However, I will now highlight for the chamber the additional reason why this count must be dismissed. This reason is this: the co-prosecutors have presented no evidence that enforced disappearances occurred. In their brief, the co-prosecutors cannot produce as much as a shred of evidence that establishes beyond a reasonable doubt that during the second movement, enforced disappearances actually occurred. They can point to no evidence, no witness testimony, nor any documentary evidence that even suggests the occurrence of enforced disappearances. In fact, the word disappearance is completely absent from the relevant portions of their submission regarding the second movement. Unsurprisingly, the evidence admitted in case 002/01 does not even remotely establish the occurrence of enforced disappearances. As we discussed in our brief, 6 witness statements were cited in the closing order in support of the enforced disappearances charge. Of those 6 witnesses, none established the facts necessary to support a conclusion that the crime occurred. 3 witness statements failed to establish beyond a reasonable doubt that the disappearances occurred during the second phase of population movement. Another documents separation between a witness and her children, but states that the witness was aware of the children's location, that the relocation was to facilitate their care, and that the witness visited them. A 5th statement described a separation of the witness from his 2 family members, but fails to offer any facts indicating that the separation was caused by an arrest, detention, or abduction by the Communist Party of Cambodia. According to the closing order, the last witness was told at a meeting that those who would refuse to leave as part of the second evacuation would be sent for re-education from where people never returned. This characterization egregiously misstates the actual language used by the witness, who neither observed nor was told nor warned of individuals being sent for re-education and disappearing as punishment for not cooperating in the second evacuation. Of the testimonial evidence heard at trial regarding the second population movement, only 2 witnesses addressed the disappearance of evacuees, but neither provided any direct or specific evidence concerning these disappearances, including the circumstances in which they were separated from the alleged victim, whether or not the alleged disappearance was the result of an arrest, detention, or abduction by the Communist Party of Cambodia cadre, or whether the cadre refused to provide access to or convey information regarding the fate or whereabouts of such persons. There is no credible evidence that any enforced disappearances took place, and there is no direct evidence to establish that Nuon Chea intended the enforced disappearance of evacuees during the second phase of the population movement, or that he was aware of a substantial likelihood that such disappearances would occur. For similar reasons, there is no evidence of the material elements of Nuon Chea's individual responsibility for enforced disappearance through any form of commission. No direct evidence exists of a directive or agreement emanating from the party center, nor is there any evidence of a pattern of conduct probative of such a policy. With no evidence to establish that enforced disappearances occur, let alone the party center's knowledge or intent in relation thereto, the only avenue available to the trial chamber is an acquittal. I will now turn my attention to the charge of other inhumane acts through attacks against human dignity, which claim that Nuon Chea deprived the civilian population of adequate food, shelter, medical assistance, and minimum sanitary conditions, thereby resulting in serious mental and physical suffering and injury. As the Chamber is aware, the testimony of witnesses was extremely varied in relation to the conditions of the second population movement. It is true that certain witnesses testified that conditions were difficult, and the co-prosecutors highlight these statements in their brief. What their brief refuses to acknowledge, however, are the statements of other witnesses who directly refute these claims. The statements which the co-prosecutors have deliberately chosen to ignore report that conditions were decent, and the health of evacuees were normal, and even that food, shelter, medicine, and land were provided by CPK cadres. These same inconsistencies are reflected in the statements of witnesses who did not appear at trial. And again, the co-prosecutor's brief dishonestly disregards them. Although some witnesses describe difficult conditions, others state that the physical health of evacuees was cared for, that food was provided during and immediately after the evacuation, and that evacuees were provided shelter upon their resettlement. This significant variance in reported condition proves that there was a reasonable doubt as to how transferees experienced the second movement. Some suffered, but many did not. Additionally, no one piece of evidence establishes the intent of Nuon Chea or the Communist Party of Cambodia to intentionally inflict upon the evacuees serious physical and mental suffering. No evidence has been presented which proves beyond a reasonable doubt that the CPK knew that the condition of the evacuation were likely to cause serious physical or mental suffering or a serious attack on their human dignity. Finally, there is no evidence to support the material elements of Nuon Chea's individual responsibility. No direct evidence exists of a directive or agreement emanating from the party's center, nor is there any evidence of a pattern of conduct probative of such a policy. With no evidence to support such a nexus between Nuon Chea and the alleged crimes, the chamber is left with no choice but to acquit Nuon Chea on this charge. Finally, Your Honor, I will now turn to the charge of other inhumane acts through forced transfer. This charge is not satisfied for two reasons that we have already articulated in our brief. One, the movement was not forced. And two, it did not occur under circumstances that render it criminal. Despite the significant attempt by the co-prosecutor have made in their brief to establish that transferees of the second population movement was forced, the fact remains that many volunteered to move to the northwest zone and were otherwise happy and willing to do so. The co-prosecutors themselves concede this point. The very fact that there are varying accounts of whether or not the movement was forced establishes a reasonable doubt and requires dismissal of the forced transfer charge. Even if it had been forced, the co-prosecutors have also failed to establish that the Phase 2 population movement amounts to the crime of other inhumane acts through forced transfer. The alleged second phase population movement was not a single cohesive event. The alleged victims, their places of origin, and the condition under which they were allegedly transferred vary considerably. The Chamber is accordingly unable to make any findings in relation to whether the so-called Phase 2 population movement was unlawful. And most importantly, if at any time the movement did become significantly serious to constitute an other humane act, the variability of the evacuees' experience establishes that decisions concerning the condition of the transfer were taken by implementing cadres. These decisions were done without the input or knowledge of Nuon Chea or anyone else within the party center. Accordingly, Nuon Chea cannot be held criminally liable for other inhumane acts through forced transfer. Mr. President, I would like to conclude my closing statement here. I thank you very much for the opportunity, but I would also like to inform the Chamber that Mr. Nuon Chea would like to make his closing statement on the 31st of October in accordance with the schedule indicated by the Chamber. Thank you, Mr. President.
President, we actually have half an hour left before the conclusion of today's proceeding. The Chamber would like to inquire from Khieu Samphan's defense whether you would like to comment your closing statement now.
No, Monsieur le Président.
No, Mr. President. We would prefer to start tomorrow.
President, thank you, Council. As time allocation has been placed for the defense team separately, and Nuon Chea defense has been allocated 2 days for the closing statements, and now they concluded earlier, half an hour earlier than the time allocated. And Khieu Samphan's defense has been allocated 2 days commencing from tomorrow, and they just stand on that time allocation. So they will commence tomorrow morning. Therefore, today's proceeding has come to an adjournment. We will adjourn now and resume tomorrow morning, that is Friday the 25th of October 2013, commencing from 9 a.m. We also would like to inform the parties and the public that tomorrow the Chamber will give the floor to Khieu Samphan's defense to present their closing statements. in case 002/01. This information is also for the support staff. Security guards started to take the two accused, Noon Chi and Keo Sampon, to the detention facility and have them return to participate in the proceeding tomorrow before 9 a.m. Noon Chi accused Sampon shall be brought directly to the courtroom, and Noon Chi shall be taken to the holding cell downstairs, which is equipped with audio-visual communication for him to participate in the proceeding remotely. The court is now adjourned.